Hello, everyone. Welcome back to another episode of the Darrell Brooks saga. On today's episode, we're going to start date 8, which is really relevant because this covers all the people that Darrell tried to use to escape. He didn't make it. We're also going to see how he got arrested. But yeah, from the time that he left his car to the time that he got arrested, this is what we're going to cover on this day. But it's always nice to see what new tactics he's going to bring to the table after speaking with his mom in the phone. But yeah, we're going to go right through it. We're going to cover the initial part of the trial and then the first witness, which I love. But yeah, thank you guys for watching. Thank you guys for giving a like to the video, for hyping the video, to leave a comment. I really like reading your comments and respond to them. It's always a nice exchange between everyone. Yeah, let's get into the video.
All right, good morning, everyone. Court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Yes, good morning, Judge Sue Upper, Leslie Basie, and Zach Witchell appearing for the State of Wisconsin.
Good morning, sir. Your name for the record, please.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments.
So if you don't dispute them, you mean to tell me that they're correct? So what they charge you is fine?
All right, the record should reflect that the individual known to this court as Darrell Brooks is present in person in custody in street clothes. He is wearing a suit, I believe a tie, can't quite see around the monitor, and a mask.
I object to that, Your Honor.
Your objections noted for the record. The appearance, as I've just indicated, stands. I do want to advise the part.
1 minute. We're 1 minute into the trial, and he's already objecting. 647 objections in 8 days. 494 asking for grounds. Ooh.
Today that one of the jurors called in this morning and was not feeling well, and I did excuse that juror. So that will mean at the appropriate time, when the court selects the alternates by random lot, I will only be selecting 3. I believe that was juror number 35. All right. Anything preliminary before the jury's brought out for the continuation of testimony from the state?
Is the audio on, Your Honor?
No.
Okay, thank you.
All right.
I don't understand that part. I don't see when the audio is on and when the audio is off, because we can hear them. Sometimes they say that the audio is off and we cannot hear anything, but now it seems to be good.
Sorry about that.
The only thing, housekeeping to clean up, Your Honor, is Exhibit 15, which was the victim map that we had first introduced through Detective Casey, and you admitted it subject to proof of all of the events that are depicted on the map. We believe we have now reached that point where it can be admitted in full. I do have a poster-sized copy of that exhibit that's also marked as Exhibit 15. So we have Exhibit 1 is the map of the downtown area. Exhibit 15 is the what we have termed the victim map, or the parade victim map. That's a hard copy of that as well, and then I have a third one that I'll be introducing later today or tomorrow. But we just wanted to clear up on 15 that all of the information on that map has now been testified to, Your Honor.
And something that I really like, and that shows how prepared these 3 attorneys are and that they're really good at their job, is that they have backups. Like, let's say that the technology fails, that they cannot project the images on the screen. They can just pull out the poster size version of it and then go through there. Like there's nothing stopping them from presenting this evidence to the jury. I really like that.
I did admit it subject to the full foundation. Any position on that, sir?
To it being admitted.
Yes, fully received. I had received it subject to foundation, and the state's set forth its position. Do you have any position on that?
Yeah, I object to it. I don't see the relevancy.
What? We spent the last week, an entire week, going through the events that map depicts. And you say that it's not relevant? It's one of the most relevant things that they are.
All right, your objection is noted, and Exhibit 15 is received. I believe I told the jury it was received subject to that foundation, but I will advise them that it's been received by the court when they come out today.
All right, and then one other housekeeping matter. Last week, I believe it may have even been on Thursday, we had a discussion with Mr. Brooks outside the presence of the jury in which several broad topics were discussed. One of them was Mr. Brooks had indicated he did not have a pretrial offer from the state. We would ask the record to reflect that afternoon we did provide him again with a written copy of our pretrial offer, and that was placed with his materials on the table. I just wanted that in the record, please.
Yeah, this was during the 50-minute rant that he said that he was never approached by a plea deal. But this is not true, as we know. His attorneys at the time got that plea, and I'm sure they discussed it with him, but he just chooses to be uninformed.
I object to that. I don't. If it was with my paperwork, I haven't seen it.
It was specifically one of the papers, sir, that you left in the bullpen area that on the next morning, on Friday morning, I made a record of providing back to you. So it was provided to you twice.
Well, I haven't seen it.
You want to put the offer on the record, Attorney Alpert?
Give me 1 second, Your Honor.
So what's the significance of it being on the record?
The significance of it being on the record right now is that they're going to tell you, you no longer are going to be able to say, I don't know, I know nothing about that. They're going to tell you, it's going to be on the record that you listen to it, and we are done with that. Because what he's trying to do is be like, I didn't read it, so I don't know what's going on. So let's not think about it. Evading.
So that you are fully aware of it, sir. It was provided to you, but you're indicating you haven't read it, so I want them to make a record of it. The significance would be, I suppose, if at any point you wanted to change your plea, you could do that based upon the pretrial offer.
Yeah.
Well, in any event, I accept for value and return for value that document whenever I see it.
Attorney Alpert, go ahead.
Sorry, it's just.
Yeah, you don't need to see it. It's fine. They'll tell you. They'll explain it to you. We know your reading is not the best.
It's taking me a second to retrieve it here, Your Honor.
Your Honor, this would be a perfect time to address the subject matter jurisdiction that has yet to be proven on the record and must be
Mr.
proven
Brooks,
by the prosecution.
we are not going to address that. I issued a written decision last week. If you disagree with that, then you can take that up to a higher court. But I issued a written decision. I'm not addressing that any further.
It has yet to be proven on record.
And remember, this is a Monday. He had Saturday and Sunday to prepare for this moment. He had time to make 100 phone calls, most of them to Erica, to call his mom boyfriend, everything to regroup and have more arguments for his defense. That's one of the reasons why I cannot get the phone calls, because they are protected as he was discussing strategy with his mom. But yeah, we're gonna see what the subject matter jurisdiction is not going away.
Mr. Brooks, my written decision is the decision of this court.
Has it
Attorney
been
Opera,
proven?
go ahead.
Has it been proven on record that you have subject matter jurisdiction? Because it has yet to be proven.
Mr. Brooks, your position is simply not correct as a matter of law. I explained that.
Then prove it
and
lawfully
I issued
by
the
law.
decision. You might be confusing subject matter jurisdiction with venue, which is why I commented on that last week.
Absolutely
and
not.
There has been evidence received regarding venue. So I'm going to turn back to Attorney Opera.
has nothing
She's
to
going to
do
make
with
a
venue,
record
Your
of the
Honor.
pretrial offer. I'd ask that you not interrupt. Thank you.
Your Honor, the offer that was dated July 5 of 2022 reads as follows. Plead to counts 1 through 67 in the information. The penalty enhancers on all counts will be struck. Counts 68 to 83 will be dismissed and read in. The state will recommend 6 consecutive life sentences on counts 1 through 6. The state will recommend unspecified prison on all other counts. The defense is free to argue. This pretrial offer was conveyed to his prior counsel on or about the July 5th date. And there, in fact, had been a earlier offer as well that had been relayed prior to the preliminary hearing or the filing of the information back in January of 2022 that had also been conveyed to his defense counsel at the time.
All right, thank you.
So basically, they were going to get rid of all the enhancers and just be like, okay, you're gonna do 6 life sentences consecutive to each other, and we're gonna dismiss the lower charges, which is still forever. Like, let's not make it this. Let's just say it like it is. It was gonna be forever either way. That's one of the reasons why many, including me, believes that he went to trial, because he had nothing to lose. He was going to be in jail forever anyway.
So why haven't I been informed of that?
Just did.
All right, Mr. Brooks, that is not a topic we are going to take up any further. I just wanted the record to reflect that offer was conveyed to you.
It wasn't conveyed to me, Your Honor.
It has just been conveyed to you right now. We just heard it. You listened to it. What do you mean it wasn't conveyed to you?
This is the first time I'm hearing of it. So if it was conveyed to my former
It's
counsel,
not something I'm going to further address, sir, unless you indicate to me that you would like to take advantage of the pretrial offer by changing your pleas to either guilty or no contest to counts 1 through 67 and submit the appropriate paperwork. I'm guessing that's not what you want to do. So unless that paperwork were to be filed, then I'm going to continue with this trial as if you are exercising your right to a trial in this matter.
and in all respect, Your Honor, I don't think it's fair that you should assume what I want to do or not, or what I don't want to do.
Well, she needs to assume something in order for the case to move forward, or else we will just be stuck and doing nothing. So she's going to continue with the trial. If you want to file the paperwork to plead guilty or not contest, you can do that, and then we can stop. But as we're going to keep moving, Brooks.
I just need to make a record that that paperwork was provided, sir. We'll continue with the testimony today. I'm not going to take up subject matter jurisdiction. I've issued a written decision. Is there any other preliminary topic from either party?
Is that decision verified proof that subject matter jurisdiction exists? Because it has yet to be proven on the record.
All right, your objection is noted. Please bring the jury out.
Your Honor, is that the answer?
The answer is that she already gave you a decision. You can take that paper, you can take that piece of paper, go to the appellant court and be like, this is wrong. She never proved subject matter jurisdiction. This paper doesn't matter. And if they agree, they're going to throw the case away. So you have hard evidence that you believe doesn't prove what you're saying. So you got it in the bag, right?
Mr. Brooks, I issued a written decision. That's your answer.
And what's that? And what does the written decision entail?
Read it.
So that was provided to you last week. I'm not going to
I accept for value in return for value the document that I have not seen. What does it entail, Your Honor?
Sir, you were provided with a written copy. I'm not going to read it into the record at this point. It is part of the record. It's a final order
If
for
it's
purposes
part of the
of
record,
appeal.
why can't it be read into the record right now?
Because it doesn't need to. It's already there. You can read it. The jury can read it. Whoever can read it. It doesn't need to waste time on that.
It doesn't need to be read into the record. Sir,
Is it
it's
verified
part of
proof
the
of?
record.
Is it verified proof of subject matter?
Mr. Brooks, I'm not answering that because it's not something that needs to be verified.
It has to be verified by the prosecution.
I heard the thing come back.
Yeah, the new thing that he added today, it was that the subject matter jurisdiction needs to be proved by the prosecution. Like he added that. He didn't have that before.
Or is that a tacit agreement that you don't have to answer that question? Or
We're still doing tacit agreement.
verified proof of subject matter
Sir,
jurisdiction?
I have no such agreement with you, tacit or otherwise. So,
Hey, you notice that she said tacit. She's desperately trying to make him say it the right way.
that's not how this operates. Again, just
So
because
would
you
it be
believe
proven?
the law requires, that doesn't make it true. All right, the jury's
Show me
coming out.
lawfully
All
law.
rise for the jury, please.
Show me by lawfully law that you have subject matter jurisdiction, because it hasn't been proven on the record. It has yet to be proven for the record. Let the record reflect that.
The record will not reflect that, and the jury will disregard the comments currently being made.
The record
just
should
made by
reflect that.
Mr. Brooks.
You have to put it on the record. Otherwise, that'd be tampering with the record.
He believes that somehow she has the power. Well, she does when she strikes something out. But she has the power to remove what everyone just heard. You cannot unring the bell. Once it's wrong, you're done. So
at 8:40,
All right. Good morning, everyone. Please be seated.
tacit agreement at 8:40.
All right. Please disregard the most recent comment by
Tacit
Mr.
agreement
Brooks.
at
It's not
8:40.
evidence in this proceeding. All right. The state may call its next witness.
Thank you, Judge. The state calls Sean Backler.
Subject matter jurisdiction
Jury will disregard that last statement by Mr. Brooks.
has to be on the record.
The first thing I will ask you to do is to state your first and last names for the record and then spell each.
Sean Backler, Sean, last name Backler.
All right, go ahead. Your witness.
yeah, I love this person. He's one of the guys that didn't take nothing from Darrell Brooks. He knew who he was. He knew that he was trying to get over him, and he fought back. And I love him for that.
Thank you. Good morning, Mr. Backler.
Hi.
Sir, on November 21 of 2021, where did you live?
Objection, relevancy.
Overruled. You may.
Oh my God. First question is already objection. She's just putting up the groundwork for her questioning. And he's already saying that it's not relevant.
409 Central Avenue, Waukesha, Wisconsin.
Okay, if you could just keep your voice up a little bit, please.
Oh, I'm sorry.
Yeah, that's maybe better if you scoot a little closer to the microphone. Okay, 409 Central Avenue, and that's in the city of Waukesha?
Correct.
Okay. Around the time of 4:49 p.m. on that afternoon of November 21, where were you?
Overruled. You may answer, sir.
I was outside working around the yard. Had my garage open.
Okay. Were you aware that the annual Christmas parade was going on that afternoon?
I was aware of it, yes.
Did you attend the parade, sir?
No, I did
Objection,
not.
relevancy.
Okay.
Overruled.
Around 4:49 p.m., what happened, sir?
Objection, leading the witness.
Overruled.
I heard some noise around on the east side of my garage, and I went to see what was going on, and I found the defendant on the side of my garage. I asked him, what in the effing hell is he doing?
Okay, so let's slow down.
Okay, now this is something that we can all relate to because these are not cops. They're just regular people like you and me. And imagine that you're just minding your business at your home, and suddenly, like a snake in the bushes, a wild Darrell Brooks appears and tries to hide or whatever he was doing. What would be your reaction to looking at someone like that? Like this little 100 pounds, 5 foot goblin sneaking around your house.
A little bit. You heard a noise and you went to explore it, correct?
Correct.
And you saw a person there?
Yes, I did.
And you questioned that person for being there, is that right?
Objection, leading the witness.
Foundational, Your Honor.
This is overruled. You can answer. I'm not sure if you did or not.
I asked him what he was doing there.
Okay. And maybe you were cursing at him? Is that what you're suggesting?
Objection, leading the witness.
Overruled.
I think I dropped an F-bomb on him.
Why?
He was trespassing.
Well, he's Darrell Brooks. That's just your first instinct when you see him. But he was inside his home, so it's justified.
Okay. The person that
There
you
was an objection, but it's overruled.
the person that you saw, can you give us a description of that person, please?
When I called it in on the non-emergency line at the Waukesha Police Department, I described him at about 5'8", probably weighed about 150 pounds. He was either black, mixed, or Latino male, wearing a red shirt, jeans, long hair, beard, and I think he was missing his shoes.
Okay. You said red top?
Red shirt.
Objection, leading the witness.
Red shirt. What kind of shirt?
Overruled, and his answer may stand.
He was wearing a red jean.
If there is an objection, please just wait until I rule on it first by saying either overruled or sustained, and I'll let you know if you can answer the question.
Okay, I'm sorry.
That's okay. Go ahead.
I believe it was a red T-shirt.
Okay. To your way of thinking, was he dressed appropriately for the weather?
Objection, leading the witness.
Overruled. You may answer.
Relevancy, objection.
Overruled.
He made 2 objections and both were wrong. The one that could have been right was speculation. Maybe. But he decided to swing twice and hit the air.
Immediately, it just seemed off because he was wearing a T-shirt. If I remember correctly, he was not wearing shoes. It was very cold out. He was sweating. His eyes were huge, and he was just acting. When he came out from the garage, he was asking if I could call him an Uber.
Okay. So you spoke with him a little bit?
Objection, leading.
Sustained as to the form of the question. Please rephrase.
Very shortly.
I have to ask him
She
the
needs to
question.
rephrase her question.
Oh, I'm sorry.
That's okay.
Did you speak with him?
A little bit.
Okay. What do you remember him saying?
He kept asking if I could call him an Uber, and then he said I need to get home.
Did you agree to call an Uber for him?
No, I said he needed to leave my yard.
Okay. And did he comply with that?
Yeah, he did. He just kept asking if I could call him an Uber, or if he could use my phone. And I said, you just need to leave. And
The person that you're describing for us, sir, do you see him present in the courtroom here?
he's sitting over there with the mask on and in the suit.
Okay, I'm going to ask the defendant be instructed to remove the mask.
Mr. Brooks, please remove your mask.
And if he would look at the witness, please, Your Honor, with his head down, it's not to assist.
All right, Mr. Brooks, please look up and look at the witness. Look at the witness, please.
And that is something that he didn't object to. They asked him, Mr. Brooks, remove your mask. And he just removed it. So I guess he is Mr. Brooks. And look at that face. That is the face of someone who knows who recognized this man even after a year. He knows who he is. He saw him on his backyard. He remembered him cussing him out of his backyard and didn't help him. That's why he's mad at him. That's a look of disdain.
Thank you.
Is that the man that you're describing that was in your backyard that you spoke to?
Objection,
Yes.
leading.
Overruled.
I want to show you a photograph. It's going to come up on that screen there next to you, okay? Just let me know when it's up. The system takes a minute to warm up, especially first thing in the morning. Is it up?
Yep, it is.
Okay. Do you see this photograph, sir?
Objection.
And
Overruled.
Yes.
I'd like you, is there a person shown in the photograph?
It's the
Objection,
defendant.
leading.
Overruled. It's not leading. You may answer.
It's the defendant.
Is this consistent with his appearance when he presented himself to you on your driveway that evening or backyard garage area?
Objection, leading.
Overruled. You may answer.
It is consistent.
Okay. Move to admit and permission to publish 171, Your Honor.
Objection, relevancy.
Your objection is overruled. Exhibit 171 is received. Permission to publish is granted.
Which is something really odd, because remember last week, he said that there were only 140 exhibits, and right now we are presenting 171. So he has no idea how many exhibits there are. Which are not being prepared is a classic theme of Darrell Brooks.
The jurors will also let us know when the image is projected in the jury box.
And sir, it's a little hard to tell in the photograph, but was the t-shirt he was wearing a short sleeve or long sleeve, if you remember?
Objection, relevancy.
Overruled.
It was a short sleeve shirt.
Okay. Ultimately, did he leave your property?
Objection, accident, answer.
Overruled. You may answer.
When he was leaving, he was kind of taking his time, and then I told him he needs to leave again and started walking towards him as he was leaving, and he lifted his shirt up and said he was unarmed.
Okay.
I don't think he was scared of you, Brooks. He walked towards you, and like a rat that you are, you slipped away into the night.
Did you ask him about any weapons?
I had not.
Objection, relevancy.
Overruled.
I had not asked.
When he left your property, did you see which direction he headed?
He was going northwest.
Okay. Thank you, sir. I don't have any other questions.
All right.
There you go. Very easy, very straightforward witness. You saw this man in your house. He left in this direction. That's all that he did. Let's go into the Brooks part of the examination.
Sir, Mr. Brooks, do you have any questions for this witness?
Yes, I do, and I object to being called that name for the record. Do you recall giving a statement to Officer Probst?
I don't know his name, but I've talked to an officer.
And you did talk to an officer that night?
I talked to an officer on the phone. I did not talk to an officer that night. I mean, on the phone I did, but not in person.
So it was a conversation on the non-emergency line. Would that be fair to say?
It was on the non-emergency line. I actually confirmed it after I called to make sure I was on the non-emergency line.
Do you recall the description that you gave at that time?
I do. Well, my best of my knowledge was that you were either black, Latino,
Who's you?
or mixed.
Who's you?
Hold on, you have to let him answer.
Ooh, he right off the bat, Darrell Brooks is triggered. Just like that. Look who's here. Look who decided to show up. It's Rory. Everyone say hi to Rory. I don't know if I was. Look at this pretty face. Look at this pretty face. He's great. She's doing great. For everyone who asked about Rory, doing great, right? Right?
Answer the question first before you interrupt him with another one. Go ahead with the description you provided that night.
I said that the individual was either black, mixed, or Latino.
So it would be fair to say you didn't know at the time.
I was giving a general description.
So it would be fair to say that you weren't sure.
I was positive it was you.
Who is you?
You. I'm looking at you.
That's a great line. That's one of the greatest lines to Darrell Brooks. It's you. I'm looking at you. I don't need to tell you who you are. I know that you were in my backyard and know that you're here. It's you. And he has no rebuttal for that.
And how did you come to that conclusion, the you conclusion?
I'm looking at you.
How did you come to that conclusion? Did you?
What conclusion? Can you restate the question?
You're saying that you gave a description on the non-emergency phone line, correct?
It was on a non-emergency line.
So it would be fair to say at that time you had no name or knowledge of who the person was in your backyard. Would that be fair to say?
I had no idea who you were.
Yeah.
And so how can you say how can you say you then if you had no idea?
I'm looking at you. You're the guy.
Yeah, this is exactly what I was talking about in the beginning. He doesn't take that for Darrell Brooks. Darrell Brooks is trying to deflect and do his whole word salad of trying to confuse the witness with the times. And he's not taking it. He's like, I'm looking at you right now. The description that I gave was the same one of the person that I'm looking at this moment.
And how did you come to that conclusion?
You and I were standing in the same yard looking at each other.
So, is it possible you saw something on the news?
About what?
No, I had no idea who you were.
Interesting.
It is?
Do you recall giving a description of approximately 5'9" and 160 pounds?
Well, he's a 5'8" before.
Yeah, something like that.
Something like that, or would that be accurate?
I didn't have a tape measure out. It was just a guesstimate.
Would it be fair to say that since you keep identifying me as you, would it be fair to say that I'm not 5'9" nor 160 pounds?
You have your shoes on or off right now?
He's calling his bluff. Like, we know that Darrell Brooks is not 5'9" and 160 pounds. But to be fair, like, he wears glasses and he was far away from him. Like, Darrell Brooks wears really baggy clothes. So it looks thicker than he is. So it's fair to say that was a guesstimate.
Would it be fair to
Also, it doesn't matter what he looks like today because he's been in jail, so he probably lost weight.
say that I'm not 5'9", 160 pounds?
If you take your shoes off and step out of them, they could have a better.
I'm not going to have them do that, but if you're able to answer the question, do you agree?
I'd have to be standing next to him. That's what I made my judgment from. We were about 2 feet from each other.
Does it look like I'm 5'9"?
I don't know. We were a lot closer.
Does it look like I'm 160 pounds?
Objection.
Grounds.
It's irrelevant as to his appearance today, just like his hair isn't in dreadlocks today.
Sustained.
Objection.
Question.
Grounds for the sustain.
Darrell Brooks got so flustered that he objected to the objection.
Next question, please.
You also said that, well, the narrative in the report said that the individual was later identified. Would that be fair to say?
Yeah, that'd be fair to say.
And so would it also be fair to say that because the individual was identified later, that's how you came to the conclusion of who it may have been in your yard?
Objection, I think that's
Grounds.
a statement, Your Honor. He's, again, reading a police report,
That's a question.
not authored by this witness. It's beyond the scope of the witness's knowledge.
It's actually the report that he
Mr.
gave.
Brooks, I've heard enough. If the objection is sustained, you may rephrase your question.
Did you follow the investigation after you had given the report on the non-emergency line?
It's kind of hard not to see it on TV. Can I clarify something? Or?
There's not a question just
Oh,
yet,
okay.
so
All right.
the state will have an opportunity to redirect if they deem it appropriate.
Okay.
Thank you.
So you made reference to it was kind of hard not to see it on the news. Would that be fair to say?
It was
Just
all
said
over the
that.
news.
And would it be fair to say that from those news reports you gained additional information that you didn't have that night?
Actually, what I did is went into work the next morning and pulled up the police report on the internet, and there you were in a
So-
mugshot. And I'm like, that's the guy.
So you got a further description from a mugshot.
No, I didn't get a further description. At the time, I didn't care who you were when you were in my yard.
Yeah.
I didn't know who you were, what you had done, where you had been, any of that
So-
stuff.
so-
all
Let him finish.
I'm saying is you were trespassing in my yard at that time, and that's all I can say. Other than that, that's all I can confirm. I don't know what you did. I don't know where you were. I don't know any of the other stuff. All I know is you were the guy in my yard.
The guy that you said was 5'9", 160 pounds.
Objection, argumentative,
Grounds.
asked and answered.
Sustained. Next question, you don't have to.
Yeah, he's being very argumentative with this witness. He's really trying to say that because he gave a description of 5'9" and 160 pounds, that means that he wasn't that person. It was somebody else that looked exactly like Darrell Brooks, but not him.
Answer that.
And what prompted you to read or pull up the police report?
Objection, irrelevant.
Grounds. He said it. He brought it out there.
Overruled, he may answer.
I was curious of actually who you were, and
what,
if you were the person that actually had done the atrocities that were on television.
and what prompted the curiosity?
A stranger was in my yard, unannounced, trespassing, asked him to leave, and they ended up catching somebody for doing something very bad, and I was wondering if that was the individual that had cut through my yard.
So it'd be fair to say at the time you wasn't privy to that knowledge yet.
Objection,
I-
vague.
Grounds.
Sustained as to the form of the question.
At the time you pulled up the police report, as you say, you had no knowledge of the identity of the individual.
I didn't know that you were going to be the person that had done that.
You keep referring to the you.
You.
Yes, you, Darrell Brooks. You. He's in the same room watching your eyes, your soulless, emotionless eyes. He knows that you were that person. He's not talking about the day off or the next day. He's talking about the now.
I'm looking into your eyes right now. You're the guy I'm talking about when I refer to you.
And the record should reflect that the witness used his right hand and index finger to point directly at the defendant. Next question, please.
So you just made reference to looking the you in the eyes, but you would need.
What would you prefer I call you?
You would need.
Because you're not going by Darrell Brooks.
You would need me to step out of my shoes to tell my height and weight, right?
I'd have to also stand 2 feet from you.
Hold on, please. Mr. Brooks, you're directed under 90611 to ask a question and not argue with the witness.
That
Thank
was
you.
the question.
It was argumentative. Please rephrase your question, and then the witness is instructed to wait until a question is asked. And if there's any objection, then I rule on it first. Go ahead, next question.
It sounds like he the one arguing.
Sure.
And this is so childish of Darrell Brooks. He's like, he started it. He started it, Mom. Like he's one of the persons that at some point he's going to call the judge mom because he hates women and he needs a mother figure to enable him.
I will disregard that last comment. Mr. Brooks, you're not testifying right now. You'll have an opportunity if you choose to do that later. Please ask a question.
Yeah, I'm gonna get to it. Any reason why you didn't give a written statement to law enforcement?
Objection, argumentative, irrelevant.
How's it argumentative?
Sustained. As to the form of the question. Next question, please.
Did you at any time give a written statement to law enforcement?
I don't believe so.
Any reason why not?
Objection,
Grounds?
argumentative and irrelevant.
Sustained.
It doesn't
Grounds for
matter.
sustain?
Mr. Brooks, please ask your next question.
It doesn't matter why he didn't do it. He's not part of his testimony.
Grounds for the sustain? You said you pulled up the police report at work the next day, right?
No, I pulled up your mugshot.
Well, you did say police report. Would that be fair to say?
Yeah.
So you can answer that.
I just pulled up a mugshot.
Right.
You don't recall saying that you pulled up the police report specifically?
I specifically wanted to pull up the picture of the person that had committed those atrocities to see if that was the person that had cut through my yard, which confirmed it was.
And did you pull up the complaint?
No.
Have you ever seen the complaint?
What complaint?
I don't believe I have.
Have you yourself filed a complaint?
Nope.
Any reason why not?
Why would you?
Grounds?
Relevant,
Sustained.
argumentative.
As to the form of the question and on relevance. Next question.
Do you recall who subpoenaed you to testify here today?
It's on the subpoena.
You don't recall?
I'd have to have the subpoena with me to read the name.
Do you recall if it was the district attorney's office?
It was.
Do you recall about how long ago you received the subpoena?
You can answer that.
A month or two ago, a couple months ago. I got a subpoena, so that's all I know, and I had to show up at a certain time.
So you knew it was a possibility that you would be called to testify?
Yes, he got a subpoena. That means that he has to show up. It's not an option.
I had no expectation of the subpoena until I went to the DA's office.
So you went to the DA's office?
They want to know. They ask. They want to see if you're worth having as a witness, or if you actually had any information that was pertinent to the case.
And so would it be fair to say that you felt that you did?
I didn't know.
Grounds?
I'll sustain as to the form of the question that strike the last response. Please rephrase.
It doesn't matter if he feels that he has information or not. That's why they call him, so he can tell them what he knows and see if they need to use him for the actual case.
Did you feel that you had information that would be relevant to the matter?
That's an irrelevant question,
Grounds.
Your Honor.
Sustained. Next question, please.
Grounds for the sustain, Your Honor?
Next question, please.
Irrelevant.
Grounds for the sustain, Your Honor?
Next question, please.
Is that a judicial determination, Your Honor?
Ask your next question, please.
When you went to the district attorney's office, do you recall whom you spoke with?
There was 3 or 4 people there. I don't recall their names. I recall their faces.
You said you do recall the names, not the faces?
No, I recall their faces, not their names.
Oh. Do you see any of those district attorneys in court here today?
I see one district attorney and one officer was in the room.
And for the record and for the jury, can you identify whom you're referring to?
I'd have to point.
And that's another thing that I like about this witness, that in order to identify them, he feels bad that he has a point. But to identify Darrell Brooks, he's like, no, that's the guy. He did it. He was the one on my yard. I like that.
I'll stipulate,
Yep.
Your Honor, I met
And
with Mr. Backler.
this officer here, sitting behind them.
All right, so the
Yes,
witness has
Detective.
pointed to District Attorney Sue Opper and Detective Casey.
And that was around the time you first received the subpoena?
It was the time that the subpoena told me to show up.
Do you recall ever being told about the plaintiff in this matter?
Objection,
Grounds.
vague.
Sustained as to the form of the question.
Do you know who the plaintiff is in this matter?
Objection,
Grounds.
vague, beyond the
Grounds.
scope of the witness's knowledge, legally inaccurate.
Sustained as to the form of the question.
Did it
He threw the whole list of objections in there, and he was like, "What? How can it be all of those?"
Attorney Opper ever tell you who the plaintiff was in this matter?
The subpoena told me who the plaintiff was.
And do you recall who the plaintiff is?
Darrell Brooks.
Again, he always asks these questions, and they always identify him. They are so confused by your question.
That's the plaintiff?
Or not the plaintiff, the plaintiff is, I think, city of Waukesha or state of Wisconsin. I'm not sure.
And it'd be fair to say that that's not a living, breathing human being.
Objection,
Grounds.
relevance.
Sustained, not relevant. Next question.
Are you aware that only a living, breathing human being can make a claim?
Objection,
Grounds.
irrelevant, argumentative.
Grounds.
Sustained for those reasons, and it's also not an accurate statement of the law.
Definitely not argumentative.
Mr. Brooks, under 90611, I need you to move on from this topic and ask a different line of questions, please.
Move on from what topic, Your Honor?
And now he's playing dumb. Now he's going a bit further, and he's trying to gaslight the judge. Like, what topic? I'm just asking questions. It's fine.
Next question, sir.
Can I know what topic you're referring to, Your Honor?
So disingenuous. So disingenuous.
Next question, please.
If I don't know the topic, how would I know to go in a different direction?
Mr. Brooks, under 90611, I need you to ask a question.
Do you know if there's even a plaintiff in this matter?
Objection, irrelevant.
Sustained. Under 90611, sir, please move on from this topic, or I will declare your cross-examination closed.
Under what law and fact, Your Honor?
Under 90611, please ask a question.
And where can I find 90611?
She already told you before. Since the beginning, she told you where you can find it. But you're not, even if she tells you, you're not going to look for it.
This is your last opportunity to ask a question, sir.
Your Honor, the jury deserves to know this information.
All right, then, the state, any redirect?
No redirect. Thank you, Judge.
All right, thank you, sir. You may step down.
All right, that's going to do it for today's first witness. It's going to be a wild ride. Like, we are starting so in gear with this witness. But yeah, we're going to go into the next episode. Thank you guys for watching. I'll see you in the next one. And remember that you're great, that you matter, and that I'm really happy that you're here. I'll see you later. Bye-bye.